Yat everybody, and thank you for joining us another season and journey in our Inside an Indian Country podcast. And I'm your host, Wesley Benally. I'm the principal and CAS leader out here in Phoenix, Arizona. Today it's probably 110 degrees and lucky to be in having conversations with our guest today, Mr. Geoff Strommer. Geoff, welcome to the show.
Thank you, Wes. Thank you for having me.
All right. Well, for those of you listening, maybe you had a chance to talk with Geoff or come across his firm. Before we get things started, Geoff, can you tell us a little bit about yourself and the space you operate in?
Sure, happy to. So I'm a partner in a law firm called Hobbs Straus Dean Walker. I'm based in our Portland office. I've been there for close to actually a little over 30 years now. And all of our clients are either tribes or tribal organizations. So 100% of our practice nationwide is focused on Indian country and representing tribes and tribal organizations and a whole range of different issues. Whatever you can think of as an issue that a tribe runs into, we probably have somebody on our team that works on that issue. Most of my practice over the past 30 years has focused on the Indian Self-Determination Act. And in connection with that statute, I've done a whole range of things from litigation to negotiation with IHS, BIA, non-BIA agencies, Department of Transportation, a whole number of different types of agencies that are involved in contracting with tribes. I've also been involved in legislative efforts to modify the statute over the past 30 years, probably a half dozen times, enact new titles, modify provisions in the statute to fix this or that issue. And then I've been involved in litigation against the IHS, the BIA, on a whole range of different issues. And I think the topic today relates directly to some of the litigation that I was involved in dealing with one portion of the statute.
Right. Yep. Definitely. Thank you, Geoff, for that, and the topic for today for specifically the 105L lease program has been a big conversation, with a lot of the clients we serve, and I'm sure with just Indian country in general. And so, really just want to say thank you. I know that, as you mentioned, whatever a tribe can get into, I'm pretty sure you're a very busy man then, with all the issues that are floating around out there. Just going to go ahead and jump into it and kind of think of some things, here for, with respect to the 105L. So when it comes to the 105L lease, can you kind of maybe just run down a little bit how that differs from traditional leasing in the sense of what we generally know what leasing is?
Yeah, I'm happy to do that. 105L, just to kind of set the stage, is a provision in Title I of the Self-Determination Act, 105L. It applies not just to Title I contracting provisions under that title, but it also applies to Title IV, which is the self-governance program within the Department of the Interior, and Title V, which is the self-governance program within HHS. It also applies to facilities that are used in the 477 program that have been integrated into the Self-Determination Contractor Compact. So it has broad applicability for all of those different programs. And it's a little bit of a misleading label because these are not leases at all in the traditional sense that I think people understand what leases are. What they really are agreements through which the federal government transfers funds to a tribe or tribal organization that is using facilities to deliver services under a self-determination agreement, and to ensure that those facilities have enough resources to be maintained, upkept, fixed, repaired, etc., so that they can be suitable for the uses for which the program is being delivered. So in that sense, they're really just funding agreements. The statute uses the term leases, so everybody refers to them as leases, and the regulations that were implemented by the IHS and the BIA use the term leases, and the courts that have examined the provision have used the term leases. So everybody uses the term leases, but they are definitely non-traditional leases in terms of how they operate.
Right. That was as I was, coming up in my career, that was one of the biggest kind of confusion things I had is like, okay, if they're leasing it, is that, like, how do we, from an, obviously there's interpretations from, an attorney standpoint, and then, from my background, just in accounting and whatnot. And, that was one of the things until I kind of got an opportunity to really dig in and think about things, is that really it just seems more like funding as opposed to a specific type of lease program or something like that. But that really does help as far as clarification on things. And, I was always kind of confused about that. So, well, it's a lease, but the substance of the agreement doesn't follow the form of the agreement, right? And that's one of the,
Right.
yeah,
Exactly.
yeah,
I mean, the federal government, when it enters into a 105L lease, doesn't take on the traditional role of a lessee. In other words, it doesn't occupy the facility. So it really, in a lot of ways, has nothing to do with traditional leases.
right,
And it's mislabeled.
right,
But it
right.
works.
Yeah.
As labeled as it is, it works.
Yeah, you're right. You're absolutely right. That's all that counts. At the end of the day. Um, and then, just as far as, just cases from initial rulings, I know you're really involved with the couple, and really just how those, kind of initial cases, and, why they were pivotal, and then, how they kind of are pushing, and maybe you can do a better explanation than myself, is getting fully funded, right, for some of these. And if you could just maybe kind of explain a little bit of that, that'd be great.
Yeah, sure. I'm happy to. So 105L has been in the statute since 1994. It was amended into the statute. And shortly after it was added to the statute, the IHS and BIA jointly promulgated regulations implementing that provision and other provisions. But the point is that it's been in the statute for a while. And uh, for the most part, the IHS and BIA, I know this for a fact with the IHS, and I assume that this is the case with the BIA. For many years, used 105L leases in not a whole lot of circumstances. It was originally added to the statute uh, primarily for IHS programs. At the time, for tribes to be able to recover from Medicare, Medicaid under the IHS framework for getting those types of third-party reimbursements, the facilities that they used needed to be IHS facilities. And one way to be able to accomplish that, if it was purely a tribal facility, was to have a 105L lease in place, which would treat it as an IHS facility. So they were not originally conceptually, I think, thought of as fully funded leases in a traditional way. They were mainly to give these facilities an eligibility status. And the IHS entered into these leases for virtually no compensation, if any at all, nominal compensation. But the regulations, of course, that were promulgated after the statute was enacted did spell out different ways that compensation could be calculated. The agency just took the position that if Congress didn't appropriate funds specifically for the purpose of fully funding these leases, then the agency didn't have sufficient funds to fully fund leases. So for many years, the full potential of the provision lay dormant in a sense. Meanwhile, the landscape with respect to, and this applies both to IHS and BIA, the appropriations side of thing in terms of providing tribes with sufficient funds so that they could maintain and upkeep facilities was in a terrible state of affairs. Both, IHS had maintenance and improvement funds, a line item that Congress appropriated annually. Operation Maintenance Fund is a similar line item on the IHS, on the BIA side, and both of them were terribly underfunded. On the IHS side, for example, tribes could expect somewhere between 35 to 40 cents on the dollar of what they actually needed through M&I funds. And similar story on the BIA side. So, of course, the net result was that unless a tribe was using its own funds, and not a whole lot of tribes have that capability, or cannibalizing funds from their programs to be able to fix these facilities, resulting in a reduction of services, the facilities themselves suffered. And I mean, you probably know the condition of facilities around Indian country has just been terrible for decades. So one of our tribal clients, the Maniilaq Association, which is a tribal organization that has a number of member tribes in Northwest Alaska based out of Kotzebue, asked us to try to figure out if there was another mechanism available other than the traditional mechanisms available for funding, to try to force the agency, IHS in that case, to fully fund a lease. So we dusted off 105L legislative history and came up with this idea that if Maniilaq submitted a proposed lease under 105L, the IHS would be required under the statute to not only enter into the lease, but also fully fund the lease at 100% of the proposed compensation level. So that happened in 2014. There were 2 rounds of litigation initially. The first round of litigation had to do with the question of whether or not a proposed lease was the subject of the final offer process in the Title V self-governance final offer provisions. And the agency took the position that it was not, that a 105L lease was not a program that was includable in a compact and funding agreement. Therefore, the final offer and rejection of final offer provisions in the statute didn't apply. In fact, they went so far as not to respond to the final offer that Maniilaq initially submitted, and ultimately that proved to be a mistake. Maniilaq sued the IHS in that case, and the district court in that case held that yes, in fact, submitting a proposal for a 105L lease was in fact allowable under the final offer process. And because the IHS treated it as not eligible for the final offer process, which provides that if the agency doesn't provide a denial or a rejection within 45 days, that it would automatically be deemed accepted under the law. So the court found, since IHS treated it as not something that could be subject to the final offer process and didn't respond, that that proposed lease was automatically deemed effective under the statute. So that was an important case because it established the rule that you could submit a proposal for a 105L lease. Up until that point, 105L was considered by the agency to be a discretionary provision, in effect. It could enter into a lease, but it was really at its discretion. So this now made these leases something that were mandatory. The agency could not just reject them outright. They were required to treat them. But the first case didn't answer really what perhaps was the key question, is whether or not, if they are required to enter into a lease, as 105L says, is the agency required to fully fund the lease? So that question was not answered in the case. The court didn't have to, because the agency didn't reject the final offer using one of the rejection of final offer grounds in the statute. So Maniilaq submitted a second lease, which ended up being the second case that was decided by the court in 2016. And that question was squarely before the court in that case. By then, the IHS smartly responded to the final offer and rejected it. And one of the grounds that they identified a number, but the key one was that they didn't have the funds available to fully fund the lease. So in that case, the court agreed with Maniilaq's position, which is that the statute requires that the agency enter into the lease, and it's explicit on its face, so that wasn't really a controversial question. But second, that the combination of the statute that talks about compensation and the regulations that offer 3 different alternatives for calculating the compensation amount that could be part of a proposal resulted in an obligation by the agency to fully fund the lease, not just enter into it, but to fully fund it if a tribe or tribal organization submitted a proposal using one of the 3 compensation alternatives in the regulations. And the agency argued that although the regulations identify 3 compensation mechanisms that can be used to calculate the overall compensation, that it still retained the authority not to enter into a fully compensated lease because Congress did not provide enough funds for the agency to do that. And the court disagreed and said, the regulations say there are 3 ways to calculate the compensation. The statute says that you're required to enter into a lease. Put those two together, and the conclusion is you have to enter into a lease and you have to provide the full compensation once calculated based on the three. And
Right.
you have to find within your discretionary appropriations the funds to fully fund these leases.
I see.
Now, the court did give the agency some discretion. So, for example, the court made it clear that the agency was not required to pay duplicative funding. So if a tribe received maintenance and improvement funds, for example, on the IHS side, it couldn't also receive 105L leasing for the same facility. So that the non-duplication factor is part of the landscape today. The other element that the agency has some discretion about is the compensation has to be reasonable. So there's a reasonableness standard that's built into it as well.
Right.
So those were the two foundational cases that kind of established the right to these leases.
I see. So when you're talking about programs in the sense that you're talking about the PFSAs, right? The program services, functions, activities. Okay. So that was a component that they initially denied, and kind of moving forward from there now. Yep.
Yeah, I mean, in Maniilaq 1, they took the position that a 105L lease was not a PSFA.
Right.
That could be the subject of a final offer, and it didn't create a responsibility on their part to reject the final offer. And the court disagreed, said, yes, it is a PSFA, essentially, and it's subject to the final offer process.
Right. Okay. Great. So, as far as what goes into the calculation of how much an entity can get funded for a lease, if you could describe maybe some of the different components of that, just to give a sense of if I'm thinking about things to get started on this, what are some common components of it, such as maybe rent, depreciation, and so forth. Just some things to kind of consider.
Yeah, so the regulations provide three different methodologies for calculating proposed full compensation. One is to get a fair market appraisal of the rental value of the facility. And most typically, that's a full service lease. So it includes, all of the costs associated with running and managing the facility. Sometimes it doesn't have to be that, but that's the most typical because it captures all the different costs associated with managing a facility and having an operational facility. There are some instances in which you can add additional costs to the appraisal if they were not built into the appraiser's methodology. So you can have a hybrid situation where you have an appraiser do an appraisal. It doesn't cover all the costs. You can add those additional elements on top of the appraised rental value as part of the compensation. So that's one methodology. A second methodology is to do basically a cost reimbursement methodology, and you identify specifically all of the costs that you incur in order to keep the facility operational and in good condition. The regulations themselves identify 30 different types of costs, electricity, maintenance, all the different costs that you would think of. The early 105L leases, the ones that were negotiated or that were the subject of the litigation, for example, that Maniilaq was involved, didn't involve appraisals. They were based on cost reimbursement methodologies. And those are challenging at times because a tribe has to be able to identify and project and anticipate how much they think they're going to spend in all of these different cost categories, which can be challenging.
Right.
And each cost element is subject to negotiation with the agency, which adds an element of challenge. And once you negotiate a compensation amount, in subsequent years, you have to renegotiate each compensation amount. So it kind of builds into the process additional steps in subsequent years, which are time-consuming and complicated. And ultimately, I think that methodology, at least in my view, doesn't result in higher compensation at the end of the day than you can get through an appraisal. The appraisal methodology is the simplest, but it has, a cost barrier in the sense that you have to pay an appraiser to come in and do the appraisal. So there's
Right.
investment up front. The compensations typically are higher than if you do it on a cost basis, 100% all the time. But because you can add these other elements on top that are not covered in the appraisal, now after 10 years worth of working with the statute and the system, the refinements have allowed tribes, I think, to be able to maximize the compensation using the appraisal methodology. And then in subsequent years, and this is important, in subsequent years, both agencies, primary agencies, BI and IHS, that deal with these leases, have agreed to simply use the base compensation of the appraisal in subsequent years, and you get a cost of living adjustment added to it. So you don't have to go through a whole new negotiation process on an annual basis.
Right.
And you can, if it happens to be a piece of real estate that in 5 years, the value of the real estate in that area has jumped up dramatically, you can go get another appraisal and then use that one. So it doesn't foreclose, the right to do that. It just makes it easier on an annual basis to build in the increases.
Right.
So 3 methodologies: clean appraisal, appraisal plus different cost items that are included in the appraisal itself, and then allowable cost item by item approach.
Right. So if I'm thinking, you can't necessarily break down any country like this, but if I'm thinking simplistically is, you have, what you would call like metro tribes where they're near metropolitan areas. They'll probably have the advantage of doing an appraisal process, just because they have probably comps nearby that could be. But then if you're a rural tribe, then that's where it probably gets a little more complicated because you don't have that type of information. And so something with respect to reimbursement, the hybrid method might be more, applicable to their situation, right?
You would think, but
Yeah.
appraisers that have been focused on 105L appraisals that I've worked with have developed ways of doing appraisals in very rural parts of the country.
Oh, okay.
Without necessarily using kind of a 3-comp approach that is a traditional approach.
Right.
And the IHS, and until recently, the BI accepted their methodologies. And they're grounded soundly in, appraisal methodologies. So there's nothing inappropriate about these appraisals. But there are, the Maniilaq leases, for example, and a lot of leases similar to the ones that Maniilaq has entered into for the villages in their region. These are leases for clinics in you don't find more remote places than, in rural, remote Alaska.
Yeah.
And there are appraisers that have come up with ways of coming up with appraisals, full service lease appraisals for those types of facilities. So the rural nature of the facility and the urban nature of the facility, I don't think changes the approach, at least in my mind. Now, the BIA just recently issued some revised guidance and policies internally in which they are insisting that there be a 3-comp approach in appraisals. And that's causing some problems, obviously, for rural facilities. And I don't think the discussion is over on that. They didn't consult with tribes before they proposed that. I think there's backlash, and it's building, and it's really inappropriate because there are too many parts of Indian country where, that kind of an appraisal is not possible because you don't have other facilities of a similar kind that are close by. But there are other well-established appraisal methodologies that still allow appraisers in those circumstances to come up with, an appropriate level of compensation.
Right. No, that makes total sense. And then as far as barriers to securing this funding, what generally do you see? I know that at least from an accounting perspective, I know you need something to the extent like 3 years of no material weaknesses on audit findings. If you could just maybe provide some insight on that, that'd be great.
Yeah, I mean, if a facility is eligible for a 105L lease, going through the steps of getting the lease are straightforward. There are no real barriers. There are some issues that come up in negotiation, and they've been subject of litigation since the Maniilaq cases, that are worth at least mentioning. One issue on IHS leases, for example, specifically, the IHS has taken a lot of tribal programs around the country, provide services to Indian beneficiaries who are eligible for IHS services. But they've also decided, and they could do this under the Indian Healthcare Improvement Act, to expand their services to cover non-Indians. So one question that has come up is whether or not the IHS is required by law to fully fund facilities, the entire square footage of the facility that provides services to beneficiaries and non-beneficiaries. Right. One case that has been litigated by the Jamestown S'Klallam tribe addressed that particular question. Jamestown S'Klallam is a little bit of an outlier in Indian country. About 95% of their user population are non-Indians, so only 5% are Indian beneficiaries. But of course, their model is we provide services to this additional non-Indian population. It brings in a whole bunch of money through third-party reimbursements into the program, and it has allowed us to provide services that we definitely could not have provided using appropriated funds because there's not enough of those. So IHS rejected a proposed 105L lease for the entire facility. And they did it based on the reasonableness standard that I described earlier that's in Maniilaq 2. And Jamestown litigated that question, and the court in that case said, yeah, there's a standard of reasonableness that the agency can use. And in that case, the agency took the position that there were so many non-beneficiaries who received services in this facility. The facility had kind of lost its character of being an IHS facility.
Right.
And so they took the position that they didn't have a legal obligation to fully fund the entire facility, but they recognized that they had an obligation to fund the square footage associated with the Indian beneficiaries. So they came up with a formula and ended up paying Jamestown about 45% of the lease value. So that's an issue. The more beneficiaries that are serviced in a facility, the more that becomes an issue of negotiation with the IHS. The other issue is one that was also litigated. So I talked about the duplication factor as the other element where the agency has some discretion. And Red Lake sought to have their compensation based on both the depreciation value of the facility, which is specifically an allowable cost, as well as the financing cost of the loan that they used to build the facility. And the agency's position there was those are duplicative costs. You can't recover both depreciation and the financing costs. Red Lake sued. They lost at the district court level, and then it went up to the Court of Appeals, and the Court of Appeals agreed with the district court. So the rule that comes out of that case is that's a classic example of duplication, where you can't recover both the depreciation as well as the construction cost, the loan cost. So those place limitations on kind of the overall compensation that you can receive. But other than those limitations, the other big one that's out there that has not really been a problem is whether Congress appropriates enough money to fully fund these leases.
Yep.
So far, Congress has appropriated enough funds. Appropriation language for 105L lease funding is unusual. It's the same language that applies to contract support costs, to the extent you're familiar with that. And it says the secretary, so HHS as well as Interior, shall have such sums as may be necessary to fully fund 100% of the 105L leases. So that's been in place now for probably 5 years. Mm-hmm. And so both agencies have had plenty of money to fully fund. Right. It's coming out of the discretionary side of the appropriation, which is where both agencies are funded. And it has grown. I mean, the latest numbers that I've seen, combined agency is, in a 7 year period since these have been available, we're getting close to $1 billion total lease value around Indian country, both IHS and BIA. So the more tribes discover 105L leasing, it's an easy one. You're interested if you learn about it because it brings in a lot of resources that wouldn't otherwise be available. The more it's going to apply pressure on the appropriations process. And hopefully, I think we'll be able to, sustain this at the appropriation level. The ultimate solution is to remove 105L lease funding out of the discretionary appropriations and move it into the mandatory approach. There was an effort that almost came to fruition during the last couple of years of the Biden administration. It hasn't really been renewed. This is not exactly the political climate when the Congress and the administration are more interested in finding ways to cut federal expenditures and to cut, mandatory obligations to really have this discussion. So it's been put on a back burner until a better political climate develops.
Right. No, that's a good point. I think you covered what I was going to ask. Is just really now that it is becoming more of a utilized program or means of getting additional funding. How is that trickling up to the appropriation level? And I think you definitely answered that question. And my apologies with respect to the three-year audits. I think I was thinking more of this self-governance process as opposed to really thinking about the 105L lease program piece of it. So, other than that, we're outside of the appropriations area, where do you see this maybe moving into the future as tribes get more aware and maybe have the means and wherewithal with contacts with people like you to help secure some of this?
Well, it has taken a direction that I find really quite interesting. I mean, I understood, from the beginning that if we were successful in getting 105L leases fully funded, that it would solve an immediate problem, which is that tribes that had facilities that were in terrible condition would have a source of fundings to repair, maintain, and upkeep those facilities. And that's happening, and it's happening on a larger scale every day with more tribes that are entering into these leases. But the other direction that I didn't anticipate, where this is really taking off, is tribes using projected 105L lease revenue on newly constructed facilities to help finance the construction of new facilities.
Right.
And, an example, and I've worked with some tribal health programs on Navajo, actually, since you're Navajo. Yeah. And we helped close a $90 million construction loan for a brand new hospital just recently. And a very important part of the stream of revenue that was part of that financing was the 105L revenue that would become available immediately when the doors were open and services started being provided out of that facility. And that was a tax-exempt facility. It had all kinds of complications. But the 105L revenue stream turned out to be a really critical part of the overall financial package that the tribe, or the tribal health program in that case, was able to put on a table. Right. The Red Lake litigation dealt with them using 105L funds to pay a USDA loan back for the construction of a facility there. And so in a sense, the way this is slowly developing on that front is that it has proven to be an important vehicle for tribes who have not been able to build new facilities in Indian country for years. And it's changing that landscape dramatically at a fairly rapid pace. So not only maintain and upkeep old, facilities, but also really look to the future and fix the problem of the backlog need of new facilities in Indian country. So it's kind of, for me, sitting where I'm sitting, it's fascinating and very rewarding, frankly, to see it develop in that direction. Now I'm going around to different tribal clients, when they're opening brand new facilities, which, 15 years ago happened, but happened rarely.
Yeah. No, that's definitely a good point. And that's, definitely seen that, all that come in tangible form. It's very cool. And thank you for all the work that have you done, and really kind of leading your firm in making this good work happen. And gonna go ahead and probably talk about this more and more, but I know you're a busy man, so I'm gonna go ahead and close it out, Geoff. And Really just want to say thank you so much for joining today. And those of you out there can definitely reach out to Hobbs Straus, their team out there, to get more information. And once again, just thank you so much for sharing some of your thoughts and ideas today. And just once again, looking forward to talking soon.
Yeah, thanks, Wes. Thanks for
Yeah.
having me. I appreciate it.